Hello and welcome to the My School channel. My name is Angela, and in this video we're going to continue the government topic by topic video lesson. So we're moving on to a new topic entitled Constitution. We're going to discuss the definition, the sources, the features and the types of constitution. So please stay with us, don't go anywhere. We'll be right back. Welcome back to the My School channel. Like I said earlier, we're moving on to a new topic titled Constitution. So let's dive right into it. Alright, so these are the learning objectives. We're going to begin with the definition, the sources, and the features of the Constitution. And then we're going to move on to the classification of the Constitution. Under each classification, we're going to discuss the definition, the merits, and the demerits of each of these classifications. So there are three different ways of categorizing the Constitution. We have the method of codification, which is divided into written and unwritten Constitution. So a country can adopt either one of them. Then we're going to move on to method of amendment, where we have rigid and flexible Constitution. And then we'll move on to the systems of government, where we'll discuss the unitary and the federal constitutions. So let's begin with the first segment. So what's a constitution? A constitution is a collection of norms or standards that govern a country. It consists of agreed upon rules and principles that define the allocation and exercise of governing powers within a nation. So when we're talking about the set of rules, the set of norms and standards that guides how a country is going to be governed, we're talking about a constitution. So it consists of rules that have been agreed upon at the beginning of the country's existence. So at the beginning of that country's existence, there are certain people who come together to agree on the rules that should guide the governing of that country. So this set of people creates the constitution for that country. So now let's move on to the next slide. All right, the constitution defines the condition for the exercise of legitimate power, who shall exercise political power and how they shall exercise their powers and the limit of these powers. So it's all about how power should be allocated within the country. So when political power is given to a certain group of people, the Constitution defines how they should exercise this power to ensure they are not abusing the rights of the citizens placed under their care. So the exercise of power, how this power should be allocated within the society, is stipulated in the Constitution. So the Constitution checks and sets limits not only to the actions of government, but also to the actions of ordinary citizens. So both the government and the citizens are guided by the Constitution. The Constitution is supreme in a country. So it guides how both government and the citizens should act. So the Constitution also states the rights, the duties and obligations of the citizens. When we're talking about rights, things that the citizens deserve within the country, and the duties and obligations are things that the citizens should do within that country. Now let's move on to the next slide. All right, we're going to discuss the sources of Constitution. Where did all these laws within the Constitution originate from? So one of the sources of the Constitution is the history of the people. So historical events such as revolutions and wars of independence often influence constitutional developments. For instance, the US Constitution was influenced by experiences of the American Revolution and the desire for independence from British rule. So just like so many other countries of the world, the United States was colonized by the British people, and so they sought for independence, and they decided to come together to agree on how the new state should be ruled outside of British influence. So based on their history with the British people and how they believe that there are certain things that they should not repeat within their states, they decided on which laws should govern both the government and the citizens within their country. So the history of the people can be a source for the Constitution based on your history with other nations of the world. Now let's move on to the next source. We also have the Acts of Parliament. So Acts of Parliament are laws passed by the legislative body in a country. So that is the duty of the legislature. They pass acts, they pass laws. So these laws can then be a source for the Constitution. They can be incorporated into the Constitution. The legislature can also amend or provide detailed implementation of constitutional provisions. So Acts of Parliament is a source of Constitution. Now let's move on to the next one. So customs and traditions can also be a source of Constitution. So these are long-established practices and norms that govern societal behavior and governmental procedures. They provide continuity and stability and often fill in the gaps where the written Constitution is silent. so they can evolve into unwritten constitutional conventions. In the United Kingdom, for example, most of their laws are usually conventions, things that they've been practicing for generations to come. So they actually make use of an unwritten constitution. So most of these conventions are what guide the actions of both the government and the citizens within the United Kingdom. So let's move on to the next source. All right, past constitutions can also be a source of constitution. So past constitutions and constitutions of other countries often provide a reference point and offer lessons from previous successes and failures. They often serve as a foundation for drafting new constitutions. In the colonial era, we had 4 different constitutions, and during the independence and post-independence era, we also had different constitutions. So all these constitutions guided how the 1999 constitution should be written based on the successes and the failures of each of these constitutions. The local government reform, for example, is present in the 1999 constitution because it has been considered a success for the drafters of this constitution. So now let's move on to another source of constitution. So we have conventions. Conventions are unwritten rules that fill in the practical details of constitutional operations and political practices. They guide the behavior of political actors and the functioning of government institutions. They often form parts of the country's constitution. Again, in the United Kingdom, they make use of conventions to guide how the government and its citizens should act. So based on how certain constitutional guidelines have been actually practicalized in their society, they define whether or not they should continue that tradition. So these conventions are those things that happened in the past that help to guide how the government and the citizens should act in the future. So they learn from their mistakes and they practice those things that continue to produce success within their country. So now let's move on to another source of constitution. We have constitutional conferences. So they are meetings and assemblies where representatives discuss and draft provisions for a new constitution. So this allows for broad participation and consensus building in the drafting process. So for most of the constitutions we had in Nigeria, before they were drafted, there were conferences where experts from various parts of the country came together to discuss what those laws that should be passed, that should be added to the constitution, and those rules and those guidelines. So constitutional conferences can also be a source of constitution. Now let's move on to the next one. So we have judicial decisions or precedents. So in modern nations, the decisions of most courts are written, collected, and published. And this collection constitutes another source of the nation's constitution. They shape the understanding and application of the law. The primary function of the judiciary is to interpret the law. So after they decide on whether or not a person is innocent or guilty, based on their decisions, those decisions they've made, they decide whether or not the law is actually appropriate for a particular country. And those decisions that they've made within the courts can also guide how the constitution will be drafted. Now let's move on to another one. We have philosophers. Philosophical ideas such as democracy, liberty, equality, and justice influence the foundational principles of constitutions. For example, John Locke's theory on natural rights and government by consent influenced the US Constitution. So we talked about how several principles, even the principle of separation of power by Montesquieu, who is also a philosopher, also influenced the Constitution of the United States of America. And we here in Nigeria, we adopted the traditions of the United States as well. So all of these principles developed by these philosophers are also in our Constitution. Now let's move on to the next slide, where we'll discuss the features of a constitution. So when we're talking about the features of a constitution, we're talking about those features that are present in most constitutions of the world. So when you see any constitution in any country, they usually possess some of these features. There are other things within the constitution, but most of these other things are specific to a particular country. So we are talking about those things that are generalized to all the constitutions of the world. So one of them is a preamble. So these are statements of ideals located at the beginning of the Constitution. So the preamble usually states the authority by which the constitutions are established and for what purpose. So the following is the preamble for the 1999 Constitution of the Federal Republic of Nigeria. So it says, "We the people of the Federal Republic of Nigeria, having firmly and solemnly resolved to live in unity and harmony as one indivisible and indissoluble sovereign nation under God, dedicated to the promotion of inter-African solidarity, world peace, international cooperation and understanding, and to provide for a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people, do hereby make, enact, and give to ourselves the following constitution. So you can see that they stated the ideals of the Nigerian people within the preamble to show that this constitution is meant for these particular people who have these values that they share as a people. So now let's move on to other features of a constitution. We have structure of government. So all constitutions specify the major organs and structure of government. When we're talking about organs, we're talking about the legislature, executive, and judiciary. So it defines whether a unitary or federal system is adopted and how powers are divided among the component units. So in all constitutions of the world, they define whether they are to adopt a unitary system or a federal system of government. It also defines the power and functions of each organ of government, that is, the legislature, executive, and judiciary. It also states the type of relationship that will exist among these organs of government, that is, whether there will be a separation of power, as in the presidential system of the United States of America and Nigeria, or full separation of power, as in the parliamentary system of the United Kingdom, together with necessary checks and balances. So it's essentially determining whether they should adopt a presidential system or a parliamentary system. So it also reveals the type of party system to adopt. Is it a one-party state, a two-party, or a multi-party system? So here in Nigeria, we adopt a multi-party system. We have several political parties within the nation. Now let's move on to other features of the Constitution. We have fundamental human rights. So all modern constitutions provide for individual and collective rights. So these rights are of two main types. We have the constitutionally granted rights, that is individual freedoms, civil liberties, social, legal, and participatory rights. And then we have government obligations, e.g. guarantees of the right to work, to education, and to safety of individuals. So for the Nigerian Constitution, it is stated in Chapter 4 of the 1999 Constitution. And these are the four fundamental rights that are stated in the Nigerian Constitution. We have right to life, right to peaceful assembly and association, right to dignity of human persons, right to personal liberty, right to fair hearing, right to freedom of thoughts, conscience, and religion, right to freedom of expression and the press, right to private and family life, right to freedom of movement, and right to freedom from discrimination. So these are all the fundamental rights stated in Chapter 4 of the Nigerian Constitution. Now let's move on to the next slide. So we have formal amendment procedures. So most constitutions state the procedures by which they can be formally amended. So very few modern constitutions, e.g. that of the United Kingdom and New Zealand, are flexible in the sense that they can be amended by the same procedures used to pass law. So just like the legislature converts a bill into law, they can also make a constitutional amendment. But this is not the case for most countries of the world. So most constitutions are rigid. That is, they are formally amended by special procedure, more difficult to accomplish than is the ordinary legislative process. So the Nigerian Constitution can be amended if a proposed amendment bill receives at least 2/3 majority votes from the National Assembly and the state houses of assembly. That means the National Assembly and the state assembly in each of the states of the Federation has to agree in order for an amendment to be made for the Constitution. Now let's move on to the next slide. All right, citizenship is another major feature of a constitution. So the Constitution also defines the qualifications for citizenship. It states who the citizens are and how citizenship can be acquired within that country. So in the Nigerian Constitution, a person can become a citizen by birth, registration, or naturalization. All right, let's move on to the next slide. All right, there are different ways of categorizing a constitution. You can categorize it by method of codification. Then we have written and unwritten. We have method of amendment, where we have rigid and flexible. And then we have system of government, where we have unitary and federal constitution. So let's begin with the first part, which consists of written constitution and unwritten constitution. So for the written constitutions are constitutions in which the fundamental principles concerning the organization of a government, the powers of its various agencies, and the rights of the citizens are set down in a single document or in a few documents. So their laws are actually written down for the people to have access to. So that is what a written constitution is. Let's move on to the next slide. So the Constitution of the United States, which was written in 1789, is a model example of a country with a written constitution. So it outlines the composition of the legislature, the executive and judiciary, and their powers. So the fundamental rights of its citizens and method of its amendments are also stipulated within the Constitution. Nigeria first adopted the written constitution in 1954 when the federal system of government was established. That was during the colonial era. So most modern states of the world adopt the written constitution, e.g. Australia, India, Ghana, etc. Now let's move on to the next slide. Alright, what are the merits of a written constitution? One of the merits is that there is clarity and proper documentation. So a written constitution ensures that all fundamental laws and principles governing the states are clearly documented. So this is important so that people can always have access to the laws. Then we also have protection of minority interests. By explicitly stating the rights and protections afforded to all citizens, a written constitution helps prevent the majority from overriding the rights of the minority. So for most of the nations of the world, they practice a democracy, and so the majority always rules. But with a constitution, the rights of the minority are also protected because they can always go back to seek redress in the courts of law whenever their rights are being denied by the majority. So we also have a defined amendments procedure. A written constitution clearly outlines the process for amendments. So this ensures that modifications to the constitution are made systematically and democratically. So this is unlike an unwritten constitution, where the process of amendment is similar to that of a normal legislative process. So with a written constitution, there is a defined method of amendments for a written constitution. And that merit is the prevention of power conflicts. So by delineating the powers and responsibilities of different branches of government, a written constitution helps prevent conflict in the exercise of power. So this separation of power ensures that no single branch becomes too powerful, and this promotes a balanced governance structure. So within a written constitution, how the power is separated among the various organs of government are clearly stated so as to make sure that no branch overextends when it comes to the use of its power and authority within the country. So there is also accessibility. A written constitution is easily accessible to the public and officials alike, allowing for ease of reference and understanding. So this accessibility promotes informed citizenry and officials, fostering adherence to the rule of law. So unlike an unwritten constitution where most of these laws are written in different documents, the citizens can access the laws which are written in a single document or just in a few documents. So this helps them to go to seek redress in the court of law whenever their rights are being abused by those in power. So they can go to the court with reference to the constitution saying the law states this and therefore I deserve so and so. So this is why accessibility is one of the merits of a written constitution. Now let's move on to the demerits of the written constitution. One of the demerits is rigidity. So written constitutions tend to be rigid due to their detailed and codified nature. So this rigidity can make it difficult for the legal system to adapt quickly to new circumstances or changing societal values. So for a written constitution, it is very difficult for the constitution to be amended because they usually follow a special amendment process. And because of this, it cannot adapt to changing situations in the society. Society tends towards change all the time, and it's very difficult for the constitution to go along with this change. So this is a demerit of the unwritten constitution. Then we have discouragement of reforms. So because the process for amending the constitution is often cumbersome, policymakers might avoid pursuing important changes that could improve governance and address contemporary issues. So it's very difficult for change to occur within that society. Then there is also difficulty in amendments. Amending a written constitution typically requires a complex and often lengthy procedure involving multiple steps such as legislative approval, referendums, or supermajority votes. And because of that, it is very difficult for a written constitution to be amended. Then we have political tension. So when different political groups have conflicting interpretations or interests, the lack of flexibility in the constitution can exacerbate disputes. So based on how these laws have been existing for a while, people can find loopholes in this constitution and they can take advantage of that. So this can lead to a lot of political tension in that country. And because of that, there is a demerit for the written constitution. Then we have frequent conflicts among the arms of government. So the detailed division of powers outlined in a written constitution can sometimes lead to conflicts among the various branches of government who may have their own interpretation of its powers and responsibility. Again, when certain people in power find loopholes in this law, they can take advantage of that. This can lead to conflicts among the various arms of government. We're talking about conflict between the legislature, executive, and judiciary in the exercise of their power. So these are all the demerits of the unwritten constitution. Let's move on to the next slide. All right, so we're moving on to another type of constitution. We have unwritten constitutions. Unwritten constitutions are constitutions in which the fundamental principles concerning the organization of the government, the powers of its various agencies, and the rights of the citizens are not codified or written down in a single document. So that's the difference between written and unwritten. One is written down in a single document or in a few documents, but the other is not. So that's the difference. Now let's move on to the next slide. All right, it is usually a combination of statutes, judicial principles, customs, and conventions which guide the operation of government. So the best known example of an unwritten constitution is that of Great Britain. So it is true that Great Britain does not have a single document containing all or most of the important rules relating to her constitution, but what is referred to as the Constitution of Britain is derived from many sources. So we have the Magna Carta Act of 1215, the Bill of Rights of 1689, the Reform Act of 1832, and the Parliament Act of 1911 and 1949. So all of these are what guides the government in the exercise of their power, as well as the citizens of the country. Now let's move on to the next slide. All right, what are the merits of the unwritten constitution? One of the merits is flexibility. Since it is not bound by a single rigid document, it can adapt more easily to new circumstances, emergencies or crises, and emerging issues without requiring a formal amendment process. So unlike a written constitution, which require a special amendment procedure, an unwritten constitution can easily be changed, especially in times of emergency or crisis within the country. It can easily adapt to emerging issues within the society. So this is a merit for unwritten constitution. And that merit is that it is easily amended. So since there is no need for a lengthy formal amendment process, necessary adjustments or reforms can be implemented quickly. So an unwritten constitution can easily be amended. It does not require that special procedure for a written constitution. Then there are fewer individual cases. The flexibility and adaptability of an unwritten constitution mean that fewer individual cases need to be resolved through lengthy judicial processes. Legal principles can evolve organically through judicial decisions and legislative changes. So for a written constitution, when they usually take this constitution to the court of law, they usually debate on the interpretation of the law rather than on specific situations. So for an unwritten constitution, the case is different. The judge has to look at specific situations rather than looking at the interpretation of the law. This means that judicial cases are usually much more fair in an unwritten constitution. This results to fewer individual cases in the court of law. Then we have quick decision making. The lack of a rigid framework allows government officials to respond swiftly to new situations without being constrained by a detailed constitutional document. So there is usually quick decision making in a country that adopts an unwritten constitution. Then there is also reduced friction among organs of government. Without rigidly defined boundaries, there is more room for negotiation and compromise, and this reduces the likelihood of conflict over jurisdiction and authority. So this is unlike a written constitution where manipulative politicians try to find loopholes in the constitution. Here there's room for negotiation and compromise among various participants in the political process. Now let's move on to the demerits of the unwritten constitution. One of the demerits is the lack of checks and balances. So an unwritten constitution may lack a clear and structured system of checks and balances among the branches of government. So this can lead to an imbalance of power, where one branch, often the executive, may dominate the others. So this is a recurring problem in most countries that adopt the unwritten constitution. The executive usually have more power than other arms of government because the power is not clearly defined within their constitution because they have no single document where the laws are written. So the executive take more power than they should within a society. There is also arbitrary government. So without a fixed written document to refer to, government actions and changes to laws may be influenced by the whims and preferences of those in power. This undermines the rule of law. So when there is no constitution that clearly delineates the power that you have within a particular system. You can go past that, past the responsibilities that have been assigned to you, and this can lead to abuse of power and the denial of basic human rights for the citizens. Then we have difficulty in public knowledge and reference. So an unwritten constitution is not as easily known or accessible to the general public. So the lack of ease of reference makes it difficult for ordinary citizens to know their rights and the limits of government power. So without a single document where your fundamental rights are clearly stated in the Constitution, it can be very difficult to seek redress in the court of law because you do not know which document contains those rights that you deserve within a particular society. Then we have unsuitability for heterogeneous societies. So in diverse heterogeneous societies with varied cultural, ethnic, and religious groups, an unwritten constitution might not provide the necessary explicit guarantees and protections needed to ensure harmony and equality. For example, here in Nigeria, we cannot adopt an unwritten constitution because we are clearly divided as it is by religious differences, tribal differences, and the likes. So it is not suitable for a country like ours. This is the reason why we adopt a written constitution. So now let's move on to the next slide. What are the differences between a written and an unwritten constitution? While a written constitution is a constitution that is codified in a single document or a set of legal documents, an unwritten constitution is not codified in a single document but is based on traditions, customs, and legal precedents. By legal precedents, I mean judicial decisions. Then examples of countries with a written constitution is the United States, India, Australia. Nigeria as well also has a written constitution. Then examples of unwritten constitution is the United Kingdom, New Zealand, Israel, etc. Then for a written constitution, they are generally more rigid and difficult to amend, while for an unwritten constitution, they are generally more flexible and easier to amend. Then for a written constitution, it is usually clear and explicit, providing a precise legal framework. You can always go with the documents, with the laws to plead your case in the court of law. Then for an unwritten constitution, it is less explicit and relies on conventions and interpretation based on the situation at hand. Then for a written constitution, it is easier for courts to interpret as it is documented. But for unwritten, there is more interpretative role for courts due to reliance on traditions. Now let's move on to the next slide. Alright, for a written constitution, it typically requires a special procedure, often more stringent than ordinary legislation. While for an unwritten constitution, it can be amended through ordinary legislative processes. Then for a written constitution, it exists in a formal written document or a set of documents. For an unwritten constitution, it exists in various forms, including statutes, conventions, judicial decisions. For a written constitution, it is easier for citizens and officials to access and understand. For an unwritten constitution, it may be less accessible and more difficult for citizens to fully understand. Then, for a written constitution, it is not useful in times of emergency because it is difficult to amend. But for an unwritten constitution, it is suitable in times of emergency. So we've come to the end of the first segment of this video lesson. I hope it was enlightening and educative. If you would like to continue with us, please go down to the link in the description below. This takes you to my school website where you can subscribe for the government topic by topic video lesson. There you can continue with us. We are going to move on to another method of categorization where we're going to discuss the method of amendments. We're going to discuss the rigid and flexible constitution. And then we're going to move on to another categorization where we'll talk about the systems of government. We're going to discuss the unitary and federal constitution. Then we're going to look at various case studies to see how we can better understand all of these concepts that we've discussed so far. After that, we're going to move on to standardized questions where we're going to answer various JAMB and WAEC past questions. I hope to see you there. I believe you're enjoying this content. If yes, please do not forget to hit the like button, click on the subscribe button, and lastly tap on the notification bell to get informed as soon as we release the next videos.